We are now proud to host a fireside chat with Judge Smith and Magistrate Judge Sullivan of the U.S. District Court for the District of Rhode Island. This fireside chat will be by Andrew Dunphy, legal fellow at the Rhode Island Center for Justice.
Thank you. Good afternoon, everyone. Before we get started, I just wanted, you are looking at over 35 years of fine time on the bench sitting in front of you. They're here today to share what they know with you, so let's make the most of it while we're here, okay? Judge Smith was appointed to the U.S. District Court for the District of Rhode Island by President George W. Bush back in 2002. Served as a chief judge here from 2013 to 2019. Was the youngest person ever to serve as chief judge in this district. Assumed senior status in January of 2025. Congratulations, Judge. Judge Smith is active in the Federal Judicial Administration and Education, serving on judicial conference committees on judicial resources, information technology, and financial disclosure, and as chair of the Federal Judicial Center's Committee on District Judge Education. He's a mentor for newly appointed and mid-career judges. Thank you for being here, Judge Smith. Judge Sullivan has served as a magistrate judge in this district since October of 2012. She played an integral role in the success of the district's Hope Court. And Hope Court is something we're going to talk about a little later, but it's a re-entry, reintegration court. It's very interesting. We'll get to it. I'm not going to steal her thunder now. She served as a presiding judicial official of the Hope Court since 2014. Her dedication to the Hope Court reflects her deep belief in the potential for rehabilitation and second chances. Really excited to talk to you both today, but I got to tell you, the irony is not lost on me. I graduated from law school 6 months ago. Here for two federal judges, I'm asking the questions. These two judges with us today have played roles in any number of judicial innovations here in this district, many of which focus on the pursuit of justice by criminal defendants and prisoners. We'll discuss several of these innovations today, and as we do so, I think we'll break it up into 4 areas of the judicial process that seem to fit well here. And the first one will be first contact. That's when a defendant is arrested and has an initial appearance before a magistrate. The magistrate has to make a decision about whether that defendant is going to be released or not, and there's a lot that goes into that decision making. That's one area we're going to cover. After that, we'll talk about sentencing, because if you have a defendant who is either pleading guilty or has been found guilty at a trial, the issue of sentencing falls solely within the discretion of the judge, and it's a very difficult decision, but I think it'll be interesting to kind of probe some of the factors that go into the decision-making there. The third part is access to justice behind the walls, and by that, I'm talking about prisoners who are incarcerated and the need to facilitate the continuing access to justice for those people. And the court plays a big role in that. And finally, we're going to talk about reintegration and the Hope major part of that, and I'm interested to talk to Judge Sullivan about it. So let's get started. We'll start with first contact. This one. As magistrate judge, you see a lot of defendants during their first contact with the court after their arrest. You have to decide whether that defendant is going to be released, whether that defendant is going to be locked up. If that defendant is going to be released, you have to decide the conditions that are going to be imposed on that release. My understanding is that in this district, the magistrate judges utilize some form of an integrated analysis that helps, kind of an aid in their decision making. And without stealing your thunder, I also understand that methodology seems to have been recognized as quite, what is the word I'm thinking of? Effective.
We're number one.
Can you comment on the factors that you balance in your decision making and how the methodology I just described brings about just results.
Absolutely. And please give me the hook if I talk too long. Topic of, I think, enormous interest. First of all, the starting point of the analysis for a federal court is always the Bail Reform Act, which is vague, has been criticized, but is actually pretty darn good because the default, that is all things being equal, here's what you do, you close your eyes, is a person is arrested, they are processed, they appear before a judge immediately, and they are released with no conditions. That's the default under the Bail Reform Act. Whether that doesn't happen and things get a little more harsh and the government gets more involved, does require a balancing. And here, I think the judicial philosophy in this district has been extremely consequential in that, and I'm going to give some credit to this guy right here. I think Judge Smith's, during the period when he was really running the district, starting whatever year you just said, we have worked really hard to develop a judicial philosophy, in particular to have our U.S. probation, which is the arm of the court, reflect a philosophy where we want to give every single arrested person, defendant, an individualized examination, balancing ultimately, we've got to balance what's the likelihood that this person, if released, is going to disappear and never come back? What's the likelihood, if released, that this person is going to go right back to hurting people in the community? Against, what are the things that we can do short of putting that person in jail, which obviously is the safe choice, is put the person in jail pre-trial and leave them there because they won't run away and they won't commit any new crimes because they're in jail. So we have to balance that. An interesting thing that I will say is we occasionally meet with judges from other countries who come to the United States and talk with judges about the work and the decisions. And one of the questions that we get, because it's a very politically fraught moment, when a judge says, the government wants this person held in jail, I think the person should be released, and I'm going to release them. And that's a personal risk for that judge, because if that individual goes right out and kills somebody, that becomes potentially the end of the judge's career. So we're number one. Just let me boast for a moment. In September of this year, our U.S. probation folks attended a national conference, and one of the things that they study is how well does each federal district do with release. And they crunched the numbers and awarded sort of awards to various districts for various things. Our district has a very good, but we're not number one, rate in releasing people. But when you factor in how good are the decisions, that is, when we release people, do they stay out of jail? Do they come back to court? Do bad things happen? We scored number one. So we were very proud. But critical to this is working with U.S. probation. And one of the things for anyone in the audience thinking of a career in this space, the work that U.S. probation does, and they're often educated as social workers in criminal justice. Occasionally they have law degrees, but they do the work for us to feed us the information that allows us to say, okay, I'm going to release you. Here are the conditions that I'm going to set for you. Here's how we're going to limit your freedom, but you're in the community. You can go meet with your lawyer. You can defend the case. Statistically, as soon as a person is put in jail pre-trial, the likelihood of a bad outcome for the case shifts markedly. So pre-trial release and detention is a pivotal part of the criminal justice system.
Thanks, Judge Sullivan. I think it's important to point out justice takes many forms, and as we talk about these decisions that you is when you're factoring in the ability to defend your case later on, I mean that the implications of that I think are great. So thank you for raising. I'm going to move it over to Judge Smith for a minute. Judge Smith, I'd like to talk to you a little bit about sentencing. Now, it's been said that deciding sentences for criminal defendants can be one of the most challenging aspects of being a judge. And there's a lot of factors that have to go into the sentencing equation. But the guiding light seems to be something about a sentence being sufficient but not greater than necessary. And I'm wondering if you would, can you comment on the judicial philosophy of sentencing here in the district? For justice not only for the defendant you're sentencing, but also for society at large.
Sure. Well, first, I want to make just a few preliminary comments just about this conference. I'd like to just congratulate all those who are involved in putting this conference together. I've been involved with the law school for many, many years, served as chair of the board for many years. Judge Sullivan's been on the board also for many years, taught here for many years. And I really think it's, this conference is an example of one of the things that makes this law school so special. Special not just in the state of Rhode Island, where it has, established itself as a force, but special in the broader community in this sort of space of doing the kind of work that is all about seeking justice, and sometimes for the people who are the hardest to have the hardest time being heard. And so I give you a lot of credit at a time when everybody's talking about all sorts of different things, to coming back to this topic at this time is really terrific. And for me personally, to see somebody come back who was my extern at 22 years ago or whatever it was, and give the keynote address at a conference like this, and sort of talk about just how impactful this school was, and people like Andy, and the experiences that he had on him and all the work that he's done. I mean, I just think this is what it's all about. And for those, I've told a few of my current and former externs who are here, there is a future for you. You can, 20 years from now, maybe you'll be giving that keynote address at a conference like this. So, just kind of personal privilege. I wanted to make that observation because I really think it's true. The second thing, just before I get to your question, and I won't spend time on this right now, but I heard some really interesting, powerful things in the panels that came before, and I hope that as we go through this conversation, I'd like to comment on a couple of the things that we heard. But going to the question about philosophy of the district, philosophy of the judges with respect to sentencing, and working a little bit off of the comments of Judge Sullivan, it's important to recognize that the magistrate judges are working at a different stage in the process. The defendants come before her for this pretrial determination of whether to release or detain a defendant. They enjoy the presumption of innocence at that stage. That's a very powerful force in the law, and she has to balance that presumption of innocence against issues like safety of the public, the need for to make sure that the trial process, that witnesses don't get intimidated, that the possibility that a defendant might flee, all of these kinds of considerations come into play that she's making. And she mentioned, that we're number one. Well, we're number one because not just because of the thoughtfulness of Judge Sullivan and Judge Almond, who's now retired, making those determinations, and that is a major factor, but also because we take, as a district, we take an evidence-based approach, and you're going to hear more about this when she talks about Hope Court. We take an evidence-based approach to making these kinds of decisions. So it isn't just about judges kind of making, intuitive judgments about somebody will be a threat or somebody will be a likelihood of to flee. That's a factor. Their intuition is really important. It goes into their judgment. But the evidence that is behind it, that's supplied by the probation office, and that's what she's talking about, and that's really critical. Now, when you move over to the sentencing function, the dynamic is different. There, the defendant presents not with the presumption of innocence, but after conviction. So the defendant is in a very different status, and we have a set of sentencing guidelines. Again, probation is critical. They've run the gamut in terms of showing us what the guidelines say, and we also have a statute, and the statute has 5 or 6 provisions to it that we are required to apply in determining the appropriate sentence, and those include things like the nature and circumstances of the offense that the defendant committed, the nature of the characteristics of the defendant. That includes all the kinds of things you might think of, protecting the public and creating deterrence and respect for the law. But to your question, the parsimony provision, which is the final provision of 3553, the statute, says the sentence shall be sufficient but not greater than necessary. And we come back so frequently, I think, to that phrase, sufficient but not greater than necessary, to achieve those goals. And I think about those words, not greater than necessary. That's the thing that I think we try so hard to focus on. I've come to believe after, a long time of doing this, 23 years of doing this, that we live in such an imperfect system where incarceration is kind of the cudgel that we use and we default to all the time in the criminal justice system for the solution to whatever problem is represented by the crime. And sometimes, this may sound silly, but sometimes I think, 100 years from now, they're going to look back at how we did things, and they're going to look at us and think, we're just Neanderthal in the way that we sort of think about criminal justice, because we always default to incarceration. And this maybe brings me to one thing I heard from the panelists that I wanted to comment on, and that was the Pennsylvania experience. I wrote down the Little Scandinavia concept. This is the kind of thing that, I hear something like that, and I think that's what we got to do. We got to have experiments like that in incarcerated environments to sort of teach us that that this cudgel that we have, this kind of idea that harsh incarceration is the solution to all problems, is really ridiculous. So now, obviously, I hope not go on too long, but obviously we're going to have reasonable minds are going to differ a lot about what is sufficient but not greater than necessary, and that's what we argue about. But my lodestar on all of this is that I really always tried to think about what is the least amount of incarceration that I can administer in a case that would achieve those results, but not go too far. And is there a possibility of something that could be done differently with a defendant that might save this person in a sense from what what will happen during a long term of incarceration. Alternatives to long periods of incarceration. So I think that philosophy is very different than the philosophy that was in the court when I started in the court, say 23 years ago, and it's really evolved very much in the direction, I think, of trying to administer these sentences as leanly or lightly as we can by still respecting the law. I believe we are still, we have been, in the last year or two, the district in the United States that varies the most from this, varies downward the most from the sentencing guidelines. We were always in a race with the Eastern District of Wisconsin, and I know the Judge Edelman there, who's been a speaker here many years ago. He's a speaker here for a similar symposium to this, and a good friend. And so I think the statistics show that we kind of have put our money where our mouth is in terms of kinds of sentences that we hand out. I think I'll stop there.
Oh, thank you. Along the idea of incarceration as kind of the default, one of the things that we talked about earlier, the three of us, had to do with the First Step Act back in 2018, the first Trump administration. And it was a bipartisan effort to reduce the federal prison population. And I'm wondering, would either of you like to comment on why you see a reduction of the prison population as a matter of justice?
It's kind of a wild card question, but a couple of things. First of all, if you go back in time, and I don't know the peak year, 1990, there were communities within this country where a material percentage of the adult males were in jail. That was perhaps racial, perhaps socioeconomic, lots of systemic reasons that you could look at for that. And the cost of the system was staggering. I mean, it is the most expensive thing that one can do, is, sustain someone in jail. So I think we as a society began to realize that, and I think the realization came from both ends of the spectrum. It came from the communities that were being decimated by this process where conduct of certain categories were over criminalized, crack cocaine to sort of pull an example, and which then clustered into a community and adversely affected a community. So those communities began to loudly complain. There's some remarkable books about mass incarceration, for example. And then at the opposite end of the spectrum, which is why I think it became bipartisan, was the folks who are paying attention to how much is government costing and what are the expenses and which expenses are stupid, where you could take an individual and say, shall we pay $60,000 a year to incarcerate you, or shall we put you back in the community and have you support your own children, work and pay taxes? And if that is actually how you can rebalance it, the answer becomes very obvious. The First Step Act, I think, was really interesting. It was complex. I personally saw a lot of failures. That is, people who were abruptly released without going through the Federal Bureau of Prisons fairly orderly and, I think, on balance, pretty good program of moving people back into the community. People were dropped in the community without a lot of preparation and failed. So I think I probably had 3 or 4 people who came into my Hope Court program and couldn't sustain themselves without criminal conduct in the community because they weren't ready. So it was complicated. I think some of the newer initiatives of putting people into the community at the end of a sentence, so they're still serving a sentence, they're still technically in the custody of the Federal Bureau of Prisons, but they are living in the community. And BOP is doing that for extended periods, and that's a really, really good thing. I certainly see, and some of the defendants I've worked with, the prison term was transformative, and now they are productive, hardworking, wonderful people trying to make their way in the world with a ball and chain around their ankles because they have the criminal history that becomes an impediment everywhere they go, everything they try to do. We're, as a society, we're working on how to fix that. So I think there are, you know, we've got this gigantic rock that we created, culminating in the 1990s, and I think we've been chipping at it and making it smaller to try and solve it at the same time that, and this is important, ultimately a criminal justice system exists as a way for society to keep itself safe from individuals who are going to be hurting other people, prevent people from doing self-help in terms of, okay, let's go lynch the person who we don't like. No, we have a criminal justice system and we trust, so we don't lynch. So we have to have a criminal justice system and it has to work. The problem, I think, was that we drifted to this incarceration approach that ultimately was unacceptable to everybody. But now we're trying to unpack it and dismantle it slowly, gradually, without collateral consequences, with some success and some failure.
So the First Step Act, I think, critically important, but from sort of the 20,000 foot view, you ask, what does the First Step Act really represent? And Judge Sullivan alluded to some of this. I think it represents an evolution in the politics of incarceration and sentencing on one hand, and also it represents the impact of education on the sentencing process. She mentioned the politics in the sense that the only reason we could get the First Step Act was because of the recognition of fiscal conservatives that incarceration is such a ridiculously expensive way to do public policy. Those people came to the light of something like the First Step Act, not because of a belief about, that we're handing out sentences that are too long. They came to it because of their fiscal conservatism. So it represents that kind of merger of interests and bipartisanship that's critical to getting good public policy done in this country. Something that we don't have much of at all right now. And the second thing is the education component. I mean, we just learned a lot over the 20 some years particularly about the difference or non-difference between crack cocaine and powder cocaine. And that was driving so much of our drug sentencing policy was this crazy crack powder ratio in our federal sentencing. And of course, over time, and it took a number of years and a number of Supreme Court cases and a lot of judges speaking up about this. Over time, we really got to the realization that, this really makes no sense. And we're putting people in jail for really long periods of time for a distinction in a drug that is just not really a distinction. Well, that education took a long time. I mean, looking back on it, it's kind of amazing how long it took for us to kind of come to a realization on that, and that makes me think about something that I heard in the earlier panel about speaking about, correctional officers who don't believe in rehabilitation. What Judge Sullivan mentioned about the failures of some of the defendants on the First Step Act, that happened because they passed the law, and it required us to go back and look at sentences, and a lot of people had served longer than the sentence that they should serve under the retroactive provisions of the First Step Act. So they were entitled to get out of jail right away, but they hadn't had the benefit of this of the reentry process. They hadn't had the benefit of the step down system of moving to a halfway house, moving to home confinement. Those things really, really work. And it's critical that we have learned that those techniques work, because what they result in is more success in terms of recidivism with defendants. So when I hear something like, "Oh, we have correctional officers who don't believe in rehabilitation," it makes me shudder, because that is exactly the problem with it's an example of the problem with our system. Whose fault is that? Is it their fault? Maybe, but maybe it's the system's fault, because why haven't we educated those correctional officers from the beginning about the criticality of rehabilitation as part of what they do, of rehabilitation being what results in success for a defendant who's coming out of prison. So we're constantly learning and hopefully getting better at this entire business, but it's really complicated and difficult business, and we're dealing with such a fundamentally important thing, the liberty of individuals, and that's the most awesome responsibility that we have as judges, is that we get to or have to decide whether somebody gets to enjoy liberty or they lose their liberty, and but we're only part of that process, and continuing to be educated and learn about and innovate in these ways that we're talking about with halfway houses and home confinement, home incarceration, interim incarceration. I could go on. I mean, we had, how long did it take for the Bureau of Prisons to come to the realization that opioid addiction should be treated while individuals are incarcerated? I mean, that was just a huge battle, and the science was really not questioned. We innovated here. That's what we did. We worked out systems where we could get people with that kind of addiction housed at the ACI instead of at the Wyatt, so that they could go through medically assisted addiction treatment, because for now they allow it, but during that time they didn't. So it's really it's a very complex world. We're dealing with so many different things, but we have to pay attention to every one of them. And this business of correctional officers not getting it on these, that I think I was disturbed by that.
Wow, thank you. There's about 10 threads that I'd like to pick up on this. Talked about innovation, and I'm expertly pivoting now to continuing access on the other side of the walls of the prisoners who are still incarcerated. And I think what I'd like to ask, though, is in this district, we have a very innovative and influential pro se clerk who assists a lot of pro se prisoners when they have a constitutional claim that they want to make. Could either of you kind of comment on some of the things that are going on in that specific area?
Sure. Well, first of all, just stepping back from what we're doing specifically in the District of Rhode Island, and what we're really now talking about are civil cases, ultimately. So to the extent that the court's becoming involved, it's the court taking up civil claims being brought by typically incarcerated individuals about conditions of confinement and the constitutionality of those conditions. That's sort of probably the biggest category. There's other categories in the space, including habeas corpuses, and actually we're getting bombarded with habes right now. This is, it's our new thing. There's a lot of habe work going on in our court. I won't even talk about it because it's all current. First of all, the First Circuit, under the leadership of David Barron, who is our circuit chief judge, when he became the guy in charge of the entirety of the First Circuit, one of the things that he immediately did was to create working groups of judges with major topics that he wanted to make sure that innovation and cutting edge, that we as courts within this circuit were all getting thoughts, best practices, and so forth. And the result of that, I ended up serving on the Access to Justice Committee. Here's the report. This was from, it's about a year old now, but it's studying, pro bono programs, best practices for mediation support of pro bono cases, and form simplification, that is, procedural tools that a non-representative and represented individual, including a prisoner, can use to work the case through the system. So the tone from the top in this circuit has been a really strong voice of bringing all the judges together to work in committees on getting this out. It's out. And then in the specifics of the District of Rhode Island, we created our own little, it's a committee led by a woman who is a force of nature. I'll say her name, Barbara Hurst. Lots of folks know her. She used to do all the state court appeals for the state defender's office. So she's actually brilliant. But she is running a group of folks based in our clerk's office who are working on enhancing access to justice for the unrepresented, most of whom are prisoners, but not exclusively, coming up with a whole array of innovations. The district had long had a pro bono panel of volunteer attorneys. Barbara took the panel, shook it, and has been out really just working the state to get the biggest law firms, the solo practitioners, the new graduates involved in the program, including mentor-mentee pairing, so that a lawyer who doesn't have the experience to try a case can be assigned and then can end up trying the case. Working on forms. She's worked with the Pro Bono Collaborative folks, and looking in the micro and very specific sense at how does the court take steps that are appropriate to facilitate access to justice, recognizing that we are a court, we are neutral. And that's really important. One of the things that our pro bono group has done is to bring the Office of the Attorney General and legal counsel for the Rhode Island Department of Corrections into the conversation, so that this isn't an advocacy effort on behalf of the unrepresented. It's a neutral effort to make access facilitated so that justice can be administered in a fair and efficient way for people who can't afford to hire their own attorney and get it done. So she actually literally published, and I of course brought a copy, on October 31, she wrote the semi-annual report to the chief judge on all the things that she's done. It's a 7-page single-spaced report, and it lists all the innovations, and each one you read, you go, wow, that is amazing. And then you read the next one. So I'm not going to read it. I'm just going to tell you that there's a lot going on.
No, I appreciate that. And, I think that the pro se litigants who try to untangle what they see as a bunch of regulations and forms and rules that they don't understand, it's incredibly helpful. And before I pivot from this, I do want to call out, because I see a number of students out there and Professor Goldstein in the back, the Roger Williams Prisoners' Rights Clinic, which I was a member of. And you guys do fantastic work, so keep it up. I want to, because I'm looking and our time is running short, unfortunately, so I'm going to move on if we can. And maybe you could just tell us what it is, what it does, and why it's fantastic.
I try to collapse all that into 2 minutes. And we had a Hope Court session yesterday, so it's kind of up close and personal. Hope Court is, it's basically a program which becomes part of post-adjudication supervision for the high-risk individuals who have moved through the criminal justice system, finished the sentence, and are now struggling to re-enter the community. And the goal of the program is to use evidence-based practices, which is really important, to provide a pretty specific infrastructure so that people move through a program with an array of supports, including mental health, substance abuse treatment, help with procuring employment, support for housing, transportation, driver's license. You cannot imagine how hard it is to get a driver's license if you're one of these people with the life history that they typically come to us with. We are dealing with individuals who have often served 10 or 15 years on a federal sentence, and that sits on top of an extensive bouncing in and out of jail life history that often begins in adolescence at the training school. And the point of the program is to move people from where we find them, where we meet them, together with the person. So the person needs to do it themselves. So the work is done, yes, by us, but also by the person, because ultimately change is miserable and hard for all of us. And what we're asking each of these individuals to do is to change, because someone who is qualified for our program, we do not allow people who can re-enter the community without a blip. We don't take them because they don't need us. And over supervision actually will drive them out of their minds, and then they'll start committing crimes because they're being over supervised. So absolutely not. We're looking for the most challenged people, and then to give that individual the supports to change themselves so that they have a set of life skills that they never had before that allows them to get up in the morning and make life choices that don't send them right back into incarceration. It's really hard. We have a lot of failures. We have a lot of successes. We have tragedies. We have participants who were doing fabulous and there wasn't enough Narcan and now they're dead. So it's very, very difficult. Most of our people are drug involved in some way. We're not a drug court. And one thing I just want to say in terms of us being brilliant innovators, we're not brilliant innovators. We simply were strongly motivated. We saw a need and we developed a program. Judge Smith was very helpful in sort of getting this to launch a long time ago. But this work is being done all over the country. These programs are typically bottom-up animals, that is, people who want to do the work, roll up their sleeves and do it. It's not top-down stuff. Now I think it gets a lot of support. State of Rhode Island has some really fine, a vets court that's excellent. I think generally we call them special purpose courts. But the idea is to use evidence-based practices, basic principles. National Drug Court Institute developed the 10 principles, I think in the 1980s, and to use those tools to structure a program that creates opportunities for people who've never had opportunities.
I didn't know about the Hope Court. Hearing that, I wish I had another hour. I have a lot of questions I want to don't, but I would like to do this maybe. I'm sure there are things that you are hoping I would ask you about today that you didn't get to address. And maybe just briefly, I'll start with Judge Smith. Give us an idea of what's on your mind that I didn't get. And certainly we'll get to you, Judge Sullivan. And then I'd like to have a few minutes if possible.
Well, I'll be brief. I'd like to just talk for a minute about this idea of innovation. Judge Sullivan said we're not brilliant innovators. So that may be true, we're not, but people are out there innovating. The whole reason we have a Hope Court and a reentry court is because of the thinking that went on in I think it was the Eastern District of Missouri. That's where it all started. It was the probation office in the Eastern District of Missouri that sort of dreamt up this idea, and it all kind of moved across the country because we meet, we talk, they give presentations like this, sparks interest. Like, well, they're doing that and it's working. Why don't we do that? And that's what that's how innovation happens in the court system. She mentioned Chief Judge Barron, creating these committees. He created one on alternatives to incarceration, alternative sentencing, and I chaired it with Judge Sorokin in the District of Massachusetts. And we too have a report like that, which is being held back for reasons I don't want to get into, but you might be able to imagine what some of those are. But we have the environment has changed a lot, but the idea, what we did with that committee, similar to what Judge Sullivan's committee on access to justice did, was we convened all the districts in the First Circuit, all the players, and we all talked about what's going on in every district and what ideas are out there, put into a report, and other districts can now learn from what the fellow districts are doing, and just continue to grow. The last point I want to make, though, is it's not just the courts and the judges. It takes lawyers. It takes lawyers to be innovating, and that's really the nature of our system. Is it's dependent on creative lawyering and aggressive lawyering, and this is the last point that I wanted picked up from the earlier topics I wanted to mention. So much of the sort of the things that we're talking about with incarceration, we're seeing the results that we see because of good lawyering and creative lawyering. no more death penalty for minors, continuing to work on the death penalty issues. There was discussion of maybe the state courts are a place to go. State courts are so underutilized for so many different reasons. I encourage you to read Chief Judge Sutton's 2 books on the state courts. So it's not just the judges and it's not just the courts; it's the lawyers that help lead us through through these things. And so for all the law students out there, that's the message I'd like to leave you with, is that you got to be part of this process of change and innovation.
Thank you, Judge Smith. Judge Sullivan, any last thoughts?
I don't know if this is a last thought, but one of the ways that the courts get deeply involved in this, and this is in the civil litigation arena, is that federally the judiciary has long been an aggressive proponent of alternative dispute resolution. That means mediation. And in the federal courts, the judges act as court-annexed mediators, and some of the mediations are right in the space we're talking about. And and I think as I look around the room, I see a fair number of faces who have worked with me in connection with mediations of these kinds of issues. And the mediation itself is confidential, but this is a hugely consequential aspect of this evolving work. And I just want to illustrate, when I arrived, the panel discussion was in progress, and there was an individual who, unfortunately, I didn't get his name. It might have been Mr. Robertson or something like that. And he was talking about solitary confinement and segregation. And he was talking about change and then tension within the institution about the change. So I went, interesting. That, of course, is the product of a mediation that I am doing. The mediation is ongoing. The public aspects of that mediation, I can't talk about anything that's happening inside the mediation, but the mediation is proceeding. There are about 6 different cases that are swept up into it. The ACLU and the local Rhode Island Center for Justice are involved on the plaintiff's side, on the defendant's side, Rhode Island Department of Corrections and the AG. And one of the observations that I'm going to make is based on my experience as a mediator, as a neutral. So I'm neutral. I'm not on the side of either side. My role is, as a neutral, to empathize with both sides equally, fairly, tolerate the fact that the empathy that I can feel for prisoners and the empathy that I can feel for the administration trying to run a prison safely, effectively, may conflict. But as the neutral, what I've found is that we have in this state some really high-minded folks trying to run a good prison. So yeah, we have some bad apples maybe sitting down in the correctional officer's staff, but whose staff doesn't have bad apples? There's a lot of work being done in an incredibly difficult environment to try to create a prison system that is at times having to function as a mental health institution, because such an extraordinary percentage of the individuals who end up incarcerated suffer from mental health conditions. And to try to provide rehabilitation opportunities for prisoners, particularly as they're getting close to release, to try to keep that revolving door of reincarceration. So I think as a mediator of these cases where it's the state incarcerated individuals and the state officials clashing, what ends up happening in my observation is that there's a lot of forward motion, a lot of progress, a lot of innovation, because I think there are really good people on both sides. The people doing the work on the plaintiff's side, but also the people doing the work, hard work, running prisons on the other side.
I'm very appreciative of the fact that you brought that up because it's something I wanted to ask you about. We didn't. That's fantastic. It rings true for the folks in the Prisoners' Rights Clinic. You know, I'm sure some of them have experienced it already, but great observation. Thank you. Allison, where am I on time? Can I take questions or not? All right. We're throwing it out to the crowd. And I want to say if any of my friends over here in particular have any questions, we would love to hear from you. I guarantee you the folks in this room are interested in what's on the minds of young.
Everybody wants to go.
Yeah, I know. I think they're having a huddle. Figure out
2:30.
who's, there we go. There's a question.
Let's go.
Oh, what a good question. You know what? We suffer from the traditional illness of just using the jargon of the business. Pro bono means for the good. It pro bono is when a lawyer does work just because it's the right thing to do, not to get paid. So pro bono lawyers are lawyers who are working on a volunteer basis. And pro se, you probably heard that one too. Pro se means for yourself. It's all Latin. And a pro se litigant is someone who is trying to bring a lawsuit and doesn't have a lawyer. They're doing it by themselves. So a pro se litigant has no lawyer. A lawyer is willing to do pro bono work, and we try to pair them up.
Beautiful. That's a great question. Thank you. Right here.
So something that both of you talked about a little bit today was just pretrial confinement. And in a system that's built on this idea of innocent until proven guilty, it seems like that should be something that's reserved for, extreme circumstances. But at least on a national scale, it doesn't seem like that's always the case. So I was curious, what are some of the ways that the District of Rhode Island has been so successful in balancing that, safety in the community with also balancing these defendants' rights? And how you guys approach that?
First of all, philosophically, we approach it by really paying attention to actually the law. The law says presumption of innocence, default is released with no conditions. And that's the starting point. And I think there are other places where they don't start there. They kind of skip those concepts and move on. But I've never worked in those places, so I can't speak to that. Our U.S. probation officers are laser focused on figuring out how to get people released safely and reliably. By that, I mean that they'll come back, that we won't lose them. They will not disappear and never return and not face the case. So when someone is arrested, literally the process is that the person is arrested at 5 o'clock in the morning. Nobody knows anything about them. They come into court. Our clerk's office staff scramble to find a lawyer. We, as a district for many, many years, and I think most of the federal districts are now copying this, we do not have someone appear before a judge without a lawyer on a felony charge. So we find you a lawyer. The person then interviews with this trained probation officer with a canned set of questions. The officer scrambles to gather as much information as possible about the person. Do they have criminal history? Have they committed other crimes? Is there a string of domestic violence? For example, I had a case where a gentleman was asking to be released on an ankle bracelet with home detention, where he was trapped in the house with the woman who he had beaten up when she was pregnant, sent her to the hospital. Probation officer found all that out in a couple of hours so that I didn't release him to that location. I can't remember what I ended up doing in that case, but the probation officer sits with the judge. The probation officer gives a recommendation based on the person's history and characteristics. The probation officer will do things like call the family and say, tell me about your son, your brother, your husband, what's going on. If appropriate, check with the employer. I say if appropriate. Sometimes a call from a probation officer to an employer means the job has ended. So we want to be very cautious about that, and they're very sensitive. And with all of that information collected, we then have a classic adversarial hearing, and the government argues for whatever they want, and the defense attorney argues for what the client wants, and the judge makes a decision. Very frequently, because we're a federal court, we're getting people charged with pretty serious felonies, we end up releasing, guided by the Bail Reform Act, which actually is pretty darn good, based on conditions. No one has asked this, but I hear this question a lot. Cash bail is a very common thing in a lot of criminal justice systems. That is, you pay your way out of jail. So if you have money, you don't go to jail pre-trial, but if you don't have money, you are incarcerated. We don't do that. Kind of simple. The only time we take security for a bond, I'm now, I suppose, expressing my personal judicial philosophy. The only time I take security for a bond is in a circumstance where there's serious risk that this person may not come back. The person personally is fairly wealthy and has some really good stuff, like maybe a mansion. So I think if he's going to lose that mansion, it's his mansion. He loves it. It really means a lot to him. If he's got to stick around or he's going to lose the mansion, that matters. That's a reason why he's going to stay. He can post that mansion. He's got plenty of money, no problems. This is not, so I say, you're released, but I want to take the mansion. So we don't take it. We put a lien on the mansion. So that if the person absconds, the mansion is lost. That happens, I'm guessing, once every 2 to 3 years. Do we get that kind of case? Otherwise, people do not pay for the privilege, the right to be released pre-trial when they enjoy the presumption of innocence in this district.
All right, I think I'm going to put a stop to it now. Our time is up, but I do want to thank you both for spending time with us today. And especially, we've got some students who are here from the Lincoln School, and for them to be able to hear some of the things that you talked about today, a valuable experience for all of us. And thank you so much.